Number 23 FB 1366.
Searching McDuffie
Assistant,
Brooks.
Assistant Public Defender Duffy Lee on behalf of Mr. Brooks. Mr. Brooks, could you state your name, please?
Montez Brooks.
Thank you. Mr. Brooks, you're here in a very unique situation because you were sentenced, and at the time you were on bond, your bond was that you had to be on Tether. And technically, until you turned your Tether in, you were still on bond. Instead of turning your Tether in, you cut your Tether off.
Un momento, por favor.
So,
I didn't.
have you had a
Miss
chance to Mr. Lebo about that?
No,
Yes.
once I got sentenced from you, I thought I could take it off, and I couldn't, so I never cut it off. And they came to the house. My Brian Levitt called me and said, "You can't take it off. You got to come up here." They came to the house and they took me to jail.
I'm sure he did. I'm sure he did.
And once they took me to jail, they came over to, I spent the night in jail. They came over there and then they cut it off. And then they say you might be charged $150 because it was like when I tried to take it off. But I never took it off and just left the house. I thought once you sentenced me that this is over with because Honorable Judge Simpson had me on the tether violation, and he gave me my bond back, and he said, just make sure you make it to Miss Washington's your sentence date. When he put the tether back on me, he said, make sure you make it. And I made it there, and when you sentenced me, my understanding, I was thinking like, oh, it's over with, but it's not, because they had to take it off. It was never taken off. It was on my leg, but I did try to take it off, and I went to jail for it. So
You cut it?
It was bothering my leg. My doctors was telling me that it does something with my disorder, because the tether that they put on, it used to be on my left leg, and they took it off, then they put it on the right. But the doctor said that with my blood disorder, it's like interacts with it. Right, and it was causing my feet to be numb at times. So that's why I was trying to get it off. And I got a rude awakening. They came and took me to jail, but I never just took it off.
Did you cut it, sir?
Yeah, I was trying to cut it.
Ms. McDuffie? Do you have a position on this?
Your Honor. Yes, my understanding is that it's basically a tamper event for the attempt to cut it. I think he was asked specifically if he cut it off, but he was unsuccessful. So it's the same, in terms of what the violation would be, it's going to be the same effect. And the question that I would have is that we discussed it at the last hearing, but there was so much back and forth about the issue with the apology letter and everything else that I didn't have a clear note on where it left off. I know that he should know better than to take it off himself. So I don't think that he ever believed that he could just do it on his own, because that shouldn't be an option with the tether. So I don't think there was a misunderstanding about that, but my notes just didn't leave off with after the request what actually was supposed to happen. So,
Yeah.
Mr. Brooks, please. And so the question that also came up when he was arraigned on a violation was, since he was not sentenced to probation, reporting or non-reporting, what is, as you mentioned, he technically was still on bond at the time. So what is violated and what's the consequence for that? So, Your Honor, I'll leave it to the court. I know that he was ordered to do community service, I believe, already.
It was.
Okay.
40 hours.
Okay.
And
So
$325 in fines and costs.
So, Your Honor, if I don't object, if the court finds it sufficient to maybe add to that somehow, I'll make a sort of unrelated request to Mr. Brooks, just for the sake of the court. If it's the Honorable Judge Simpson, then I don't think it should be Miss Washington. So maybe some consistency with the respect to all the judges there. But other than that, if there's anything that the court would want to request, I would just defer to that.
Thank you. Thank you, Ms. McDuffie. I appreciate your comments.
Mhm.
Mr. Lebo, anything you want to say?
Your Honor, I do agree that Mr. Brooks is not on probation at the moment, so I'm not sure if he can be sanctioned for a probation violation. Obviously, he displayed some very poor judgment in attempting to remove the tether himself. I don't quite understand why he believed that was appropriate. I do believe he's already been penalized for this by his brief incarceration after the Tampa event, in addition to the fact that I'm sure that he's going to be charged for any charged monetarily for any damage that occurred to the tether.
So although it's not a violation of the court's probation, it is a bond violation. There was an order of the court that he remain on that particular tether, and he remains on that until he goes to get that taken off at the community corrections. So he violated a court's order. In essence, what I will do at this time, sir, is order that you serve 1 day in the Washtenaw County Jail. Credit for the 1 day, sir. And it is an order that you must any fines or fees related to the cutting of the tether. As far as your original sentence was concerned, I was going to just allow that to be the sentence and not have much follow-up regarding it, but I'm going to schedule a review to make sure you're doing what you're supposed to be doing. If you haven't done that, sir, then you can go on probation. Do you understand that?
I understand.
The review in this case will be in 60 days on March 21st, 2024 at 10 o'clock a.m. Do you have any questions about what you need to do, sir?
No, I don't.
See you back here on March 21st at 10 a.m.
Okay. Thank you.
You're welcome.
Thank you, Your Honor.
Okay, thank you. Muchas gracias. Yes. No. Yeah. I had 2 years of German. And what a waste. You just don't use that a lot in the Southwest.
Right, it was kind of bulky and it was making everything fall.
On Kenneth. We now call Kenneth Williams, 21-37322, 37449, 37590. Mr. Burbank is the attorney for Mr. Williams.
Click on the name and then hit choose document and choose the document we need.
Come on forward, sir. You were Kenneth Williams. There are 3 cases pending, 21-37322 and 21-37449. evading detention with a motor vehicle, and assault on a peace officer. You had pleaded guilty to those cases. And as part of a plea agreement 21-37590, having a prohibited substance in a correctional facility is to be dismissed.
That's correct.
Is that the plan? Okay, that's the way I'm reading this. Now, you entered pleas to the second degree felonies of evading arrest, detention with a motor vehicle, and assault on a peace officer. A pre-sentence report has been prepared in this case. Have the parties, in these two cases, have the parties had an opportunity to review it? And are there any corrections or changes?
We have, Your Honor, I know there's nothing from the state.
Then it's made a part of the record for all purposes here. And the agreement in these cases, sentences to be run concurrently, I believe.
Yes.
And the agreement is a cap of 12 years in prison. So we are looking at no less than 2, nor more than 12 years confinement in prison in each case. Deferred or unadjudicated probation is an option up to 10 years in length on that probation. Also, is there anything preventing the court from considering regular, so long as the sentence is not above 10 years in prison? I could sentence him no less than 2, no more than 10 years confinement in prison, and then suspend those sentences and place him on probation up to 10 years in length in those two
The
cases.
only thing I think is
Assault,
the assault, if there's an alleged deadly weapon. I don't think it alleges a deadly weapon on the assault.
does not. I think that's an option as well. State, you think
That's
so?
correct. Yes, Your Honor.
Okay, so there's a potpourri of things we can do in dealing with this. Now, I have received some additional information regarding the defendant. I've received something dated 12/12/23, which appears to be a handwritten letter from Tyrus Williams, and also a typewritten letter from Kenneth Williams. And how are they related to? Is Kenneth Williams you? Did you send me a type letter? Okay, your father. You are a junior. And then these are 2 letters and envelopes, which are duplicates of what I have here. Well, just having. So Tyrus Williams is your brother? Yes. You've been in custody now about 2 years? each of these letters state that your problems seem to be centered around drugs and alcohol, misuse of. Why? I'm sorry.
That's how I've been really sparse. Reason.
Well, no, but I mean, but drugs don't act on their own. You know, they don't kind of walk around and whisper, "Hey, take me, take me." You know, you make the choice. Well, why is your choice making poor when it comes to drugs?
Growing up around,
Sir?
just growing up in the streets around.
Well, I mean, we all grow up with that stuff around us, but we make a choice whether we want to. But we all know better that it's evil. It's not, unless it's medical. It's going to hurt you, and it's a crime. It's illegal, but it's evil because it can make you dependent. You don't want to. You want to be independent, don't you? You don't want to be dependent on anything, anyone. You want to be able to stand on your own 2 feet and make wise choices. How many times have you been to rehabilitation help? Nothing? These letters, one final thing I want to check on here. So I did on orange highlighting here earlier, and is there a restitution here?
No, Your
It
Honor.
says he crashed into another vehicle.
Yeah, I was able to speak with that individual. They really were not very cooperative in wanting to deal with this
Really?
case. I did call and speak with her.
And it says here that the police who have experience and training in this sort of thing believe that there was a cigarette dipped in PCP phencyclidine in the car. Is that what you were using? Phencyclidine? Phencyclidine. That's about the worst thing you can use, you know. They call that embalming fluid on the street. It's called embalming fluid because it's used to embalm the animals when they're dead. Can you think of any wise reason a human would, consume such a thing? It doesn't make any sense, but I know people do it, and they're in here, and PCP kind of keeps you from being normal. Okay, so we've got a DWI from 99, another one in 18, resisting arrest, driving while intoxicated, assault, bodily injury. So it looks like we have 5 misdemeanors, an aggravated robbery here in 2000. He was placed on deferred probation. That was revoked, and he was sentenced to 15 years TDC. Is that right, sir?
Sure.
Then DWI, third, 10 years in 21, 10 years in prison, probated for 8 years. And how did you do on that? Did you complete the probation?
I actually got on probation in November.
I'm sorry. You mumbled. I didn't
I
hear you.
actually got on probation in November.
Okay, so you completed the probation in Newton?
No, sir. I came to court in December, and my bond was revoked. I've been in custody since.
But have they revoked your probation yet?
No, sir.
They let it run.
Okay, but it's a conviction nonetheless, right?
Yes.
Okay. I mean, are you?
Yes,
is he classified
yes,
as an
sir.
habitual
Yes,
felon?
sir.
So, what are we looking at here? Okay, so, but on the plea agreement, we proceeded under second degree felony punishment? Is
That's
that what we
correct.
did? Okay, number one, there was an agreement that was fashioned so that you would not be subject to habitual felon status. You would be looking at a minimum of 25 years to life. That's what you were looking at because of your criminal history. So number one, your lawyer was able to fashion a deal that you were not subject to a minimum of 35 and a maximum to life without a life imprisonment with this cap of 12 years. So number one, that's pretty good. Then the next thing is you're looking at between 2 and 12 years in prison as a potential sentence. Okay. I think I know where we stand on this. Go ahead, Mr. Burbank.
Well, at least you know where you stand, Judge. It's kind of rocky on the defendant's side. As the court is well aware, he started back in '85, was been to the penitentiary at least twice. He is a habitual. He's been in for almost 2 years.
He also had that 2 years TDC in 2019. Aggravated robbery in 2010 that was revoked in 2002, and then the regular probation. So he's got 3 convictions, 3 felonies.
And with this case here, we realize that he has not broken the cycle in reference to drugs and hard times with the PCP, as the court has enlightened everyone on. I asked that the court take a look at page 5, though, in the recommendations. And I think that Mr. Williams was very candid and forthright this time. I think because of his age, and we've talked about it before, he said during the pre-sentence investigation interview, the defendant expressed that he has a serious problem with using intoxicating substances and need for treatment. Well, he's been like this all his life. The reality is, Judge, is that you can give him the 12 years. He's got 2 in. He may make it home before us today. I'm just being sarcastic because it's a non-3G offense. My recommendation, and what Mr. Williams asked me all along, and the only way that I could argue this is that he wants drug treatment. And he needs a lockdown facility, which would be Safe P. If the court would consider, because of his habitual status, either one, because they're second degree felonies, allowing him to plead true to an enhancement to make it a first degree felony, which would make it 5 to 99 life if he does not do good on probation with the court, because it is deferred and he's subject to whatever the range is. I probably would not recommend habitual, pleading true to 2 allegations for deferred probation because of his track record. But that's up to Mr. Williams, depending on how, whether or not he's blowing smoke to the court, or whether or not he truly believes, because of his age and what he's been through, enough is enough and it's time to get off the train. And I would ask that the court maybe want to ask Mr. Williams in reference to maybe some of the options. Court, of course, the judge is, the court is completely right. You could sentence him to some time on one and then place him on probation or deferred probation on the other. And that would probably send him to rehabilitation. But penitentiary, this is a classic example that penitentiary does not rehabilitate. It pushes him along, and here we are today. With them in trouble.
State, Your Honor, I believe that the 12 years is more than a fair offer. And that's what I'm asking the court to sentence him to. And the alternative, the court did place him on probation on one of the cases. I would ask that it be again the deferred with him pleading to a habitual status on that, if That's what he was wanting to do. Be serious about getting help with his drug addiction. Get a resetting. You can go.
I've got a resetting on the audio.
Okay. What do you want to say, sir?
What do you want?
I think, yeah, like I expect probation is really true. I'll be willing to sacrifice it. Visual, if I'm gonna step on probation. Like I said, 40 years old. It's time to get together with some professional drug treatment. I think I can get it right.
All right. I think I know where we stand, everybody. What I'm going to do is fashion a sentence. You have to pay for continued mistakes. We've got cases here, and both are second-degree felonies. What I intend to do is place the defendant on sentence the defendant for a flat time on one case, and place him on deferred or unadjudicated probation on a second case with ordered treatment. And we're going to focus on that treatment. If you fail to follow that treatment properly, fully, then your probation can be revoked, and I can bring you back and sentence you up to 20 years in prison. You understand? Okay. Don't think I won't with your rich criminal history, because you're about to get another conviction, which will put you in five convictions. I think total now felonies with your aggravated robbery, your DWI, your illegal possession of controlled substance. 4. It'll be a 4th felony conviction. And what I'll do is you've served 2 years, and what we'll do is that sentence will be a 10-year sentence with credit for time served toward the completion of that. When you have completed that, you have to pay a price. Then you will be placed on deferred or unadjudicated probation, which will include substance abuse, felony punishment, facility attendance, and other conditions of probation to assist you. And that supervision will last up to 10 years. But once your sentence on evading arrest is completed, then this assault on public servant, which will be placed on deferred, you will be having to deal with helping yourself responsible. Can you do that? So I'm going to, if nothing further to add, I'm going to find in clause number 21-37322, I'm going to find you have pleaded guilty voluntarily in each of these cases, and 37449, each of these 2 cases, evading arrest and detention with a motor vehicle and assault on a public servant, both second-degree felonies. You have pleaded guilty in these cases voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted here in each case to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in 21-37322. The evading arrest or detention with a motor vehicle, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years, and you will be given credit for the time you have served on that case, which is 2 years already. In 21-37449, the assault on a public servant, even though there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, I'm going to defer any finding of guilt on that case.
place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Plus, in your case specifically, there will be additional terms and conditions of probation to assist you and require you for attendance in a facility safe P, we call it substance abuse felony confinement and assistance and SAFP F, which is substance abuse punishment facility assistance, and you must follow those terms and conditions of probation, which will help you with your long-term serious issue of dependency on frightening drugs, serious drugs such as phencyclidine. But we're going to walk it back a step. It's all about conscious decisions we all make. You have chosen to make poor choices over time. Phencyclidine is lethal. You're lucky to be still alive, but you need to make better choices. There are people who are supporting you, your family and friends, who say you're worth saving and giving another chance. But at the end of the day, you've got to walk on your own 2 feet and make your own independent decisions and act responsibly. You know what's right versus wrong. You know what's good versus bad. My question to you, do you want to do the right thing? Do you want to make the right choice? Some people, unfortunately, don't. But there's no reason you shouldn't make the right choices, especially with a support group. Too many people are in front of me, and I get no letters from anybody. They're hopeless for the most part. They're not going to get any help to help them if they can't help themselves. But you have help. You're fortunate. It's a blessing. My question is, are you going to make good use of that blessing, or are you going to fritter it away? What are you going to do? Well, you got to put forth a real effort. Are you able to do that? So, well, we're going to keep an eye on you. If you fail, you'll be back before me, and it won't be pleasant. So make the most of this opportunity, sir, and use them. Rely on assistance and advice from the people who care for you very much, who are close to you, and who seem responsible according to these letters. So you're capable. Your DNA says you can be as good as what I do. Make the right choices. You let yourself down, you let others down who are behind you. Don't do that. Promise? Committed to it? Well, we'll see. See the probation officer. Thank you. That is all. We're going to have to take a short break here. I've got to deal with Andrew Weller's case. And
should be in
the deferred probation order should be in file.
Yeah. Or 449.